The big news today, Attorney General William Barr just released a 4-page summary of Special Counsel Robert Mueller's report on alleged Russian interference in the 2016 election. So the report found no evidence that the president's campaign conspired or coordinated with Russia to influence the election, but it did not come to a definitive answer on whether or not Trump obstructed justice. So joining us right now, Attorney Mark Reichel, criminal defense attorney here in Sacramento, also have some federal experience, so that is why we're bringing you in today. Thank you so much for being with us today, Mark.
Thanks for having me.
All right, so let's break this down, what we have so far. Essentially, it's just a 4-page summary, and it's got 2 parts. On the collusion conspiracy question, Mueller found no crimes, no charges there. On the obstruction question, he essentially just punted to the DOJ. What do you make of that?
That's understandable. This is about indicting a president. We're making a recommendation for an indictment. So, number one, he defers it to the Attorney General with the faith that the Attorney General and Rod Rosenstein, the Deputy Attorney General, will do the right thing. But there's also an escape or a safety valve, I think, that Mr. Mueller knows about, and that's that he can, in that report, he'll have all the facts. The law is already known. It's in the books. So the elements of the crime are there. But he has all these facts and how many pages it could be. Congress is most likely going to get that. So if Congress says, look, Mr. Barr made the determination he didn't want to press charges and file it, Congress can still say, look, these are enough facts that we consider this a high crime or misdemeanor, could do impeachment or could hold hearings with sanctions and so forth.
Yeah, so there's a lot that we don't know yet because we haven't seen the full report. You mentioned the congressional part of it, but the president's not out of the woods yet either because there's also the Southern District of New York, right, and a number of other ways that he may face legal trouble.
There are all sorts of pending investigations. There's no dispute that obviously Russia interfered with the election, number one, and secondly that people associated with the current president, Mr. Trump, had things to do with that Russian interference, but not colluding is what they're finding now. It's a simple report. It's a summary, we have a simple summary of a really big tome. It's a big encyclopedia. We've got the Reader's Digest version that came out today from Attorney General William Barr.
William Barr was appointed by President Trump. So was it the right decision by Mueller, you think, to defer the obstruction question to the DOJ?
I think there's no dispute that William Barr is clearly a partisan and he's an advocate for the president. He's been that way for a long time. However, I think Mueller, no matter who the Attorney General was going to do this. And I think he thinks it's probably not his place to call for the indictment of a sitting president, but instead to just lay out all the facts and to give the report on. And it's very carefully worded, the summary we're talking about, which, as you said, is we're early on. It's very carefully worded by William Barr about obstruction. And he says, he clearly says that there's a lot in it that Mueller wrote, and he makes a determination, that's Barr, to not press the charge.
Okay. Most of the news coverage was on the collusion and conspiracy portion. But people forget obstruction of justice is what got Richard Nixon impeached. That's why this is such an important question. So what actually is obstruction of justice? Because a lot of people say just by the president tweeting, intimidating witnesses, that is obstruction of justice.
You know, that can be, but obstruction of justice, first of all, like you just said, the big catchphrase in the law, in the federal law, is it's often not the crime, but it is the cover-up. And like you say with the Nixon administration, that's what it taught us. It's a rather vague statute, so as a result, judges in courtrooms really want it to be narrowed down factually to show there clearly is intent, because once you think there's an investigation of you, you can do all sorts of things to defend yourself and to fight back that could be interpreted as, influencing or corruptly trying to stop the investigation. So we want to give a lot of leeway, actually. We want to make sure we can prove that your intention was to corruptly, illegally impede or obstruct.
Okay. Mark, we just have time for one more question. So I just want to ask you legally where we go from here.
Legally where we go from here is that clearly there's going to be a showdown, I think, in the Supreme Court. I don't think the Trump administration is going to want to give the entire report. Congress is going to demand it. The Democrats really want it.
Okay. When we get the full report, we will probably have you back. Mark, thank you so much for being with us today.